Afternoon. Thank you so much for joining us. We have an amazing panel for you on the future of our rights in the post-Dobbs era. My name is Gaston Alonso. I am the director of the Ethel R. Wolf Institute for the Humanities. And I just have three quick notes. If you're a student and you came in order to receive extra credit, if you didn't sign in on the way in, make sure you sign in on the way out. Second, a recording of this event will be available in the Wolf Institute YouTube channel. And at the end of our commentary, we will make sure to leave time for questions on the specific topics addressed by our panelists. And with that, it is my honor to introduce my colleague from political science, Professor Paisley Kara.
Thank you very much. I'm really delighted to be here, and I'm delighted to have been asked to moderate this particular panel. So it's a real pleasure. So okay. So it's not on, but I'll speak loudly for the moment. A little bit. How's that? Oh, that's much better. Okay, thank you so much. Anyway, so you have the bios of the participants, so we're not going to waste time on that. We're going to get right into it. The first speaker is the Hess Scholar-in Residence, Melissa Murray, Frederick and Grace Stokes Professor of Law at NYU, and many other things, including co-host of the Strict Scrutiny broadcast, which is the most informative and entertaining podcast you could ever listen to. So.
I'll pay you later. Thank you. So the title of the panel is Dobbs and the Future of Individual Rights. And let me just start off by saying, what Dobbs does. So as we have discussed in some of the other panels, Dobbs withdraws a constitutional right. It overrules Roe versus Wade, which in 1973 recognized the right of a physician in consultation with his patient to counsel the patient to choose an abortion. And Dobbs overrules that, withdraws that right. There are two other points about Dobbs that I will try and underscore here. There are a number of different opinions in Dobbs. One of the ones that I think that got the most attention is the separate concurrence of Justice Clarence Thomas. It is a separate concurrence, it's a solo concurrence. No one else joins Justice Thomas in this concurrence. But in that concurrence, Justice Thomas refutes something the majority opinion is at great pains to say. So the majority opinion in Dobbs very much tries to sequester the question of abortion rights from the other rights of heart and home that are undergirded by the 14th Amendment's substantive due process principle. And in Dobbs, the majority opinion, Justice Alito makes clear, we are just dealing with abortion, and abortion is singular, it is idiosyncratic, and our decision here in Dobbs on abortion does not affect these other rights, including the right to use contraception, the right to marry someone who is of a different race, the right to marry someone who is of the same sex. None of those other rights are implicated by what we do here. The dissenting justices in Dobbs, Justices Breyer, Kagan, and Sotomayor, note that that kind of logic doesn't make any sense. Roe was undergirded by the same substantive due process principle as these other cases that have recognized the rights to contraception, the right to interracial marriage, the right to same-sex marriage. And if Roe is suspect, then all of these other cases recognizing these other rights are similarly suspect. And it is on this point that Justice Thomas intervenes to say, exactly right. The dissenters have it right. Justice Alito cannot make the claim that Dobbs is sequestering abortion and leaving aside these other rights because that just isn't true. And with that, Justice Thomas invites his colleagues on the court and invites the public through lawsuits to revisit the question of these other precedents. Griswold versus Connecticut, which is the 1965 case that decided the right to contraception. He leaves out 1967's Loving versus Virginia, which cemented the right to interracial marriage. Who knows why? He also invites the court to reconsider 2003's Lawrence versus Texas, which decriminalized same-sex sodomy, paving the way for 2015's Obergefell versus Hodges, which nationalized the right to same-sex marriage. So all to say that Justice Thomas and the dissenters are in agreement that this panoply of rights is very much on the table. Dobbs is talked about as a case dealing almost exclusively with substantive due process and substantive due process rights. I want to suggest that the majority opinion doesn't really talk about substantive due process, and that is part of the reason why the Dobbs analysis is the way it is. When Justice Alito withdraws the right first conferred in Roe, he is talking about the fact that there is no textual basis for the right in the Constitution, nor is that right to abortion deeply rooted in the history and tradition of this country. He doesn't really talk about the impropriety of recognizing rights under substantive due process. And in an article called Dobbs and Democracy, Kate Shaw and I argue that part of the reason why he elides that discussion of substantive due process is because substantive due process might be the way in the future that the court chooses to recognize the rights of the fetus as a rights holder in both constitutional law and statutory law. So there might be a very good reason why Justice Alito steers clear of substantive due process, even as the dissenters and Justice Thomas are very much engaging it. The second thing I will say about the majority opinion in Dobbs is that if it is inattentive to substantive due process, it is not inattentive to equal protection. I was one of the law professors who wrote a brief in Dobbs, a friend of the court brief, an amicus brief, in which we argued that in addition to substantive due process, equal protection might be a home for the abortion right. And we made the argument that under equal protection, the court, or Mississippi rather, would have to show that its abortion restriction was one that served certain purposes, that were substantially related to important governmental purposes, and that Mississippi had not made that case in its defense of its 15-week abortion ban. Justice Alito spends about 5 seconds dealing with this equal protection claim, and most of his discussion of it really focuses on why the Equal Protection Clause is foreclosed as a home to root the abortion right. And he turns specifically to a case also decided in the 1970s, Geduldig versus Aiello, in which the court determined that discrimination on the basis of pregnancy was not discrimination on the basis of sex because not all women get pregnant. That's the logic of that decision. And the logic of that decision was so evidently wrong that Congress immediately in 1978 passed the Pregnancy Discrimination Act, which made discrimination on the basis of pregnancy sex-based discrimination for purposes of Title VII, the part of the Civil Rights Act of 1964 that deals with employment discrimination. And in subsequent cases like United States versus Virginia, which was decided in 1996, and Nevada versus Hibbs, which was decided in 2003, the court appears to invalidate or at least call into question the validity of Geduldig as a precedent going forward. The court in United States versus Virginia makes clear that in order to sustain sex-based discriminatory laws, the government has to have an exceedingly persuasive justification for making the distinction on the basis of sex, and Hibbs shores that up. Justice Alito in Dobbs makes no mention of United States versus Virginia and makes no mention of Hibbs. I think that's really important here because I would argue that his decision in Dobbs and his treatment of equal protection is not just about overruling Roe and finding no basis for the abortion right in equal protection, but limiting our understanding of constitutional equal protection going forward. It very much relates to an argument that Justice Scalia advanced in dissent in United States versus Virginia when he argued that women were not really a minority group because, in fact, they are a bare majority of the United States population. And Justice Alito, in the Dobbs opinion, notes that women are not without electoral and political power. And notably, the recent spate of ballot initiatives in which individuals have gone to the ballot boxes and secured reproductive freedom for themselves on the state level might actually play into that argument that women are able to marshal majorities in the political process and therefore may not be the kind of discrete and insular minorities that the court is obliged to intercede to protect under the logic of equal protection. So I will just say there are a lot of individual rights that Dobbs calls into question, not just the ones that Justice Thomas identifies, but maybe also, and perhaps more profoundly, the equal protection rights that are flagged in this one brief part of the opinion and which play a role in some of the cases that the other panelists will talk about.
Thank you very much. Our next speaker is Nelson Tebbe, the Jane M.G. Foster Professor of Law at Cornell Law School and the current Kluge Chair in American Law and Governance at the Library of Congress.
Thanks. It's a total joy to be here. I've never been to Brooklyn College before, even though I live in Brooklyn. And I'm like super excited to see the place and to meet all of you. Thanks to Gaston for putting this all together. He did an amazing job, he and his team at the Wolf Institute for the Humanities. I'm especially pleased to, help to honor Melissa Murray, who I'm just a huge fan of. She is both a first-rate constitutional theorist and a media star. And I was sitting here trying to think about whether that combination has ever existed previously, and not in the last generation of, giants in constitutional law, and I don't think among any of her peers in this generation either. It's really a remarkable space that she fills, and we're lucky as a public, as Americans, that she's here to explain constitutional law to all of us, and then as theorists to figure out exactly what's going on in our constitutional law. I'm enormously admiring of her, and I'm thrilled to be here. Okay, so our topic is Dobbs and the future of individual rights, and I'm going to address that topic. I'm going to offer some thoughts about other rights other than reproductive freedom, especially rights of speech and religion. I think it's tempting to think that individual rights are being systemically underprotected by the Roberts Court. Dobbs is an example of that. The Roberts Court actually rescinded an important fundamental right. And it has a supermajority of conservative justices. And so I think people might think like, okay, the future of individual rights is bleak under the Roberts Court. And, to a certain degree, that's true. People have in mind the liberal Warren Court from the 1950s and 60s as a court that, instantiated, really helped to perpetuate or to create a rights revolution in the United States, strengthening individual rights across a range of areas. And I think people assume that the Roberts Court is kind of the opposite of that, retrenching individual rights in lots of areas. But I think on closer inspection, things are quite a bit more complicated than that. The Roberts Court is also aggressively using judicial review to invalidate democratically enacted policies, including by enforcing individual rights. So this is not an era of judicial deference. This is not simply the inverse of the activist Warren Court. Even within particular areas, such as freedom of speech or freedom of religion, the future of individual rights can look bleak or rosy depending on the issue. So rather than asking about individual rights as such, or even conducting an analysis kind of right by right, it might be more helpful to frame our inquiry around particular constitutional domains, and then to zoom out and try to characterize our constitutional politics more generally. And so that's what I'm going to try to do in 6 minutes. A further complexity is that in some of these areas, there are intense debates among conservatives that are playing out right now. So judges and law professors on the right are debating whether the governing rule for the Free Exercise Clause should be scrapped and what should replace it, a version of strict scrutiny or something like the history and traditions approach that the court has applied in the gun rights area or in Dobbs itself. These conversations on the right are in some ways, even more consequential than conflicts between the right and the left right now, because there are 6 conservatives on the Supreme Court at the moment. They can basically do what they want. Okay, so in my remaining time, I'll spend a few moments trying to sketch out the future of individual rights, first by addressing freedom of religion and then freedom of speech. And I'll pay attention to the relative strength of protections, to the methodologies that the justices are using, and to internecine debates among conservative constitutionalists. Okay, here we go. All right, so with regard to religion, a new kind of paradigm is emerging in the constitutional law of free exercise and non-establishment. When it comes to government benefits, formal neutrality is being put in place, and that means that religion must be supported alongside secular analogs on exactly the same terms. So separationism, policies of separationism by the states are styled as discrimination on the basis of religion. And so, for example, religious private schools have to be funded alongside secular private schools. When it comes to government regulation, on the other hand, the rule is not neutrality, the rule is liberty, substantive liberty. So religion receives special protection on the regulation side. Exemptions and accommodations are afforded that are not available to others. So an evangelical cake baker is exempted from the civil rights requirement to serve LGBTQ customers. A business corporation run by Christians can refuse to cover female contraception, its health insurance for employees, and so forth. So you see how that works? There's sort of a requirement of equality when it comes to benefits, but special protection when it comes to government regulation. That combination I call with co-authors in recent work structural preferentialism. It leads to a constitutional law that across areas prefers religious interests. Let's step back and think about what that means for the future of individual rights. Free exercise, the right to practice your religion, has a very bright future. Right now, the governing rule is that believers do not get special exemptions from general laws that apply in the same way to everyone. But the court is using exceptions to that rule as well as statutory protections to award powerful exemptions to religious actors. This term, the term that's pending right now, for example, the court is poised to exempt religious actors in two cases, Catholic Charities against Wisconsin and Mahmoud against Taylor. In the first case, Catholic Charities is asking to be relieved from a state law that requires employers to pay into the state unemployment insurance system. Because that law exempts churches themselves, but not social service organizations like Catholic Charities, the argument is that that's discrimination on the basis of religion. It's very likely to prevail in the Supreme Court. In the second case, Mahmoud, religious parents want to opt out from aspects of the public school curriculum that they oppose, elements that support LGBTQ diversity, among other forms of inclusiveness. Because religious families can opt out of the sex education curriculum, they say that refusing to exempt them from parts of the regular curriculum is discrimination on the basis of religion that should be struck down by the court as unconstitutional. Again, they're very likely to prevail. So that's free exercise. On the Establishment Clause side, though, the part of the Constitution that protects what we used to call separation of church and state, that's being weakened in a rather dramatic way that's reminiscent of Dobbs. So if free exercise is sort of very strong individual rights, on the Establishment Clause side, the right, if you can call that, is being dramatically weakened. The courts even overruled the Lemon Test, which had been the main rule for non-establishment cases for 50 years. This term, for example, a case that's currently pending, is called Drummond, where the issue is whether the state of Oklahoma must fund religious charter schools alongside secular charter schools. The big debate in the court is whether charter schools are public schools. The idea is that if they're private schools, then maybe it's true that they have to be funded alongside secular charter schools. But and if they're public schools, then the idea is that they can be required by the state to be secular. But there's almost no discussion in the Supreme Court of whether Oklahoma is permitted to fund the Catholic school at issue under the Establishment Clause. Whether that school is considered public or private, it ought to be a real question whether the government can support the school, in fact, establish it, because it doesn't currently exist with public money. Okay, so that's the religion side. You can see it's a kind of mix, right? In some ways, individual rights are being strengthened, in other ways, weakened. What about with regard to free speech? Free speech is thought to be another kind of favorite individual right of the Roberts Court, unlike reproductive freedom or the Establishment Clause. But there's a surprising debate among conservatives here, too, on core questions of expression. Let me give you two examples. One is digital platforms, social media platforms, and the other is universities, like the one we're sitting in. Regarding platforms, the main conservative view traditionally has been that private entities that host the speech of others cannot be regulated by the government in the interest of a fairer speech environment. That's the typical view among conservatives. So newspapers cannot be forced to carry rebuttals from people who are criticized in their pages. That's a violation of the newspaper's free speech right under the conservative view. Similarly, the court held last term in the Moody case that massive social media corporations, among the largest corporations in the world, had speech rights against state regulation that sought to impose anti-discrimination requirements on them. These were requirements that were designed to protect conservative speakers on social media platforms. You can think of this as kind of free speech Lochnerism, for those of you who follow these debates, extended to digital commerce. But there's a split among conservatives on this issue. So movement conservatives are questioning this traditional view. Florida and Texas are red states that passed platform regulations at issue in the case, and Justice Alito, joined by Gorsuch and Thomas, and following a kind of, I think, radical opinion by the Fifth Circuit, held that states can regulate large media companies in order to ensure a fair speech environment, exactly the position that liberals had previously taken. So there's a political inversion. Conservatives are adopting arguments that liberals previously made, and there's a split among conservatives about free speech and what it means. Maybe I'll skip universities in the interest of time, but just to summarize, there's been a kind of similar inversion about universities where arguments about the civil rights of students are being made by conservatives that used to be the domain of liberals, and arguments about free speech are being made by liberals that used to be the domain of conservatives. What's more, there's a split among conservatives on these questions. Not all conservatives agree about campus speech rights and how they should be protected right now. So when we step back and think about the future of individual rights, I think it's quite a complicated picture. Some rights are favored, some rights are disfavored. If we want to generalize about this, like try to think about what lessons we can draw, we might say that the Roberts Court is engaged in a politics, a constitutional politics of kind of like anti-wokeness or resentment or something like that, where they're trying to protect kind of traditional mores or traditional ways of life in the face of radical change. Thanks very much.
Thank you very much. Our next speaker is Alina Dobbs, professor of clinical law and James Weldon Johnson Professor of Law at NYU School of Law and co-director of the Immigrant Rights Clinic.
Thank you. Well, thank you all for being here, and thank you to the organizers of this event, and thank you to Melissa for being amazing, giving us a reason to gather together to talk about these important issues. So my domain is in the world of immigrant rights. So I take the question here, which is really thinking about the state of individual rights, about the fact that rights that we have relied upon are being withdrawn by the courts, and that there is this kind of history and tradition analysis that seems to be very outcome-oriented. How does that impact the world in which I sit, which is defending the rights of immigrants? And I think the question is very complex, because quite frankly, all of certainly Supreme Court precedent, but much of the law in the area of immigrant rights has been outcome-oriented from the start, where the few rights that have been recognized in our laws have been very hard-fought, and there are so many caveats written into the precedent that it almost begs the kind of debate that we're having now, where there are certain rights that we thought were available, and now there's a question of, well, how do they apply? And so just taking us back to some of the foundations, immigration law is already set up in the context of legal fictions. So based on fights that were had early on, where during periods of time where the Supreme Court was permitted and was openly racist and xenophobic in their discussion of these issues, the Supreme Court has adopted a series of legal fictions that underlie all of the fights that we're having now. So the idea that deportation is not punishment, legal fiction. The idea that detention is not punitive incarceration, legal fiction. The idea that you can physically be here in the U.S. but treated as if you are outside the borders, legal fiction. And now there are growing debates as to really personhood of immigrants immigrants based on status, which are percolating in the conversations that we're having on a number of issues. I will focus maybe taking the prior comments as an entry point on immigrants' First Amendment rights. So my own role at the Immigrant Rights Clinic has been defending immigrants from deportation and detention, often in the context of the intersection between immigration law and criminal law, a lot of what people probably traditionally think of as grounds that a person might face deportation from the United States. But because of the work of my clients, during the first Trump administration, we had to enter into the foray of First Amendment rights because we had a client who was a very notable activist, leader of the New Sanctuary Coalition in New York City, who was suddenly detained. And we had been representing him for maybe a decade at that point when he was detained at a point and giving us the signs that perhaps he was being targeted because of his activism and not because of the myriad other reasons that the administration was pursuing deportations. And so for this man being in a defensive posture, we had to argue the First Amendment issue that, and as it unfolded through the litigation that we brought on his behalf, his name is Ravi Rugbear, we were able to uncover evidence that this was retaliatory. And all of the arguments about whether he could even raise a First Amendment argument to a federal court, what First Amendment protections he might be entitled to, whether the fact that he was an immigrant who had an old deportation order meant that they could essentially do whatever they want for any reason. All of that had to be argued before a court, and we were, for a brief moment in time, successful. So we were able to argue to the Second Circuit, which is the appellate court in New York, that and they agreed that yes, absolutely, you do have a right to go to federal court to raise a claim of retaliatory deportation. Courts do have the ability to review that, and that retaliating against an immigrant for criticizing immigration policy is a form of outrageous discrimination that fit into one of the exceptions, an older law that basically said we don't really allow selective enforcement claims, but here we do fit into the exception. And so that was a moment in time, and I say that was short-lived because then based on a different jurisdictional case that has to do with individuals seeking asylum who are subject to expedited removal, there's a question about the extent of habeas powers, like whether a court can review it. And so they said, we're not reaching the merits, but we are going to send the case back down to consider the question of whether this even applies. And then by that time, through all of the organizing work that communities across New York City and across the country were doing on behalf of immigrants who had been similarly targeted, we were able to ensure that the Biden administration put in guidance and policy that they would respect the First Amendment rights of immigrants, and they ultimately settled Ravi's case along with the several other cases that we ended up bringing on behalf of activists to give them an opportunity. And I am happy to say that on his last day, in the day before he left office, President Biden gave Ravi a presidential pardon, which allows him to be safe from deportation. And so we enter this second period of time with the Trump administration, wondering whether we were going to see a similar pattern. And what we're actually seeing unfold on college campuses, it's hard to say, just like how many times can I be shocked, but is deeply shocking and all the more disturbing because unlike in Ravi's case and the myriad other activists who we've represented who are immigrants, in those cases, there was actually an attempt to say, nothing to see here, business as usual. No, it's not retaliation. This has nothing to do with their remarks. And then forcing us to fight, and as would be the case in any traditional First Amendment retaliation case, that's usually what's said. And then there's a burden shifting and whatnot that allows you to parse out whether retaliation was actually involved. Here, the stated policy from the moment members of our community have been abducted from their homes and the streets and taken to remote detention centers, the stated policy is that these people are being targeted for not only speaking out, but for the actual content of their speech, the viewpoint that they are expressing. So in any other world, this would be classic First Amendment retaliation, viewpoint discrimination, and again, all these different tests would kind of kick in to challenge that. And yet here we are for all of the cases that, we are one of many incredible attorneys who are representing Mahmoud Khalil. There are a number of other students and faculty who have been similarly targeted and have lawsuits pending. For all of their cases, we are still at the earliest stages of the fight, not because it isn't clear from the face of what's going on that there is a First Amendment question here, but because the individuals who are being targeted are immigrants, and every status-based reason to question whether they can go to court, which court they can go to, whether they even have First Amendment rights, all of those are being presented by the government, citing precedent that does exist in different contexts, and basically piecing together pieces of our very ugly history in the United States to kind of create something entirely new. So I think one of the things we have to confront when we think about the assault on individual rights and how it cuts across different dimensions is that it isn't it's essentially what we see in immigration, and this isn't just in the context of First Amendment, but across the board, is that status becomes the vulnerability, and all of the judicial schemes that have been created, they're used to essentially erode rights in this context because people are not U.S. citizens, even though the First Amendment is not an amendment that talks about citizenship. So it's used as a tool, but then the erosion of those individual rights affects all of us. So all of our First Amendment rights are harmed when you have precedent that, again, and I am hopeful, I believe that the courts will say no to this, but if they were not to, if they don't, that is something that will erode all of our rights, and that is by virtue of many of the individual rights that are in the Constitution that are really framed in a way where it's not just about the individual. We want to be able to speak freely and to listen because that benefits all of us to have a free and robust debate. And so we see these things evolving in real time. Again, what's happening, it's not the first time it's happened by any means where immigrants have been targeted because of their speech. It's surely not going to be the last time it happens, but we are in a moment where the issues are front and center. And so we should expect that our courts will be able to address these issues front and center and be honest about what is happening, rather than buy into some of the government's arguments that because we are talking about immigrants, because we are talking about people who might be green card holders or student visa holders, or in some contexts, again, not in this particular context, but in other contexts, maybe people who, like Ravi, have a deportation order, or people who may be undocumented, that somehow that status diminishes their rights or our interest in protecting them. This is a moment where we're hoping that courts will stand up, and I think the voices of people who have come in allyship around these issues have been incredibly important to underscoring why that is it's a vital moment, and it will be a test for our constitutional rights and for our democracy. So with that, I'll end.
All right, so Gaston has generously allowed me to give you, say maybe 5 minutes worth of remarks, and I can't speak extemporaneously, but I really can't sitting down. It's weird muscle memory, so I'm going to go quick. So I'm not a lawyer, so that's my excuse. I'm going to stray from the individual rights aspect of the talk and talk about how attacking trans rights is actually going to harm everyone. And I think it's the correct argument, but I also think I want people to care about trans rights for a lot of reasons. So what I'm going to talk to you in my very brief remarks is about how President Trump's attack on gender and his executive order defending women from gender ideology extremism and restoring biological truth to the federal government, how it harms not just trans people, but women, cisgender women, even men. So the larger argument, which I won't get into today, is sex helped build the state and the nation as a category through marriage laws, through anti-miscegenation laws, through property laws and coverture, through things like the Page Act and cross-dressing laws. And sex, as in sex classification, is also seems to be becoming a tool in dismantling the administrative state. So this is really quick. How is this happening? Well, let's turn to Project 2025, which turned out to be kind of prescient in like what Trump planned to do. The lead author of Project 2025 wrote, "The next conservative president must make the institutions of American civil society hard targets for woke culture warriors. This starts with deleting the terms sexual orientation and gender identity, diversity, equity, inclusion, gender, gender equality, gender equity, gender awareness, gender sensitive, abortion, reproductive health, reproductive rights, and any other term used to deprive Americans of their First Amendment rights out of every federal rule, agency regulation, contract, grant, and piece of legislation that exists." So that was in Project 2025, published, I think, in 2023, and there's so much in there. Who knew what they were going to do? Turns out they're doing it so fast. So I don't know if you've been following what's happening with the National Institutes for Health and the CDC. All those web pages, not just to do with LGBT health, but women's health have come down. So I've been calling it the Great Deletion. So what Trump wants the federal government to do is define sex at conception, defined by who has the bigger gametes and who has the smaller gametes. Like biologists if they're not so upset, they're laughing. It's just like, it's an insane, unworkable definition. But when you're the president, you have this thing, political scientists talk about a lot called the force of law. You kind of get to say what the law is. So that's a bit of a problem. But let me give you a couple of examples how this harms everyone. Okay, so if you mandate that you will only fund research that uses this particular definition of sex, here are some outcomes. So it's funny, I'm becoming very sciencey in my old age, but doing all this research. But here's an example. Because black women have historically had hysterectomies at higher rates, they are less likely to get cancers of the uterus. Because the uterus, if you want to look it up, is part of when you have a hysterectomy, your uterus is removed. If researchers are forced to use women as defined by President Trump, instead of only those with uteruses when calculating the incidence of these cancers, they miss significant racial disparities. So this has got to do with math. But if all black women are in the denominator, and black women with cervical cancer are in the, what is that, the numerator, the top, the thing on the bottom, you get like a lower incidence. But if you only count black women who actually could get cervical cancer, you find a higher incidence. So this is like a famous epidemiological example of like being accurate. So when you use Trump's definition of sex, you miss on the fact there's a 44% racial disparity in cervical cancer. Black women are 44% more likely to get it. So I try to use this example to show like these definitions harm everyone. Another example, in the early days of COVID, it was noticed that men were dying at much higher rates, and some people who were doing the journalism said, "Oh my God, there's these biological differences. What are they that cause men to have die of COVID at higher rates?" And then the people at Harvard's gender science lab, they kind of delved into the data, and they're like, actually, men do different things because of socialization. Like they don't wear masks because it's not as much as women because of ideas of masculinity, and they're more likely to have jobs in the public sphere. So there were all these gender differences that accounted for the COVID death rates differences. But under the new Trump administration plan, you couldn't measure that. You would just be able to look at, is it chromosomes? Or no, I guess is it the fact they have small gametes at birth? So I don't want to talk too long. I just want to end there. So the Trump administration attack on transgender people is also an attack on the administrative state. And what I think the answer is, what Trump has done, we might call militant stupidity. Like the definition is stupid, but what we need to do is actually fight the militancy, fight the politics that produces this definition. So I'll end there. And finally, our last speaker of the panel is delighted to welcome Chase Strangio to Brooklyn College. He is the co-director of the ACLU's LGBT and HIV project, and he has argued before the Supreme Court last December. He was on the hot seat in Skrmetti, so very excited to have him here.
Well, thank you for having me here. And I also am excited to celebrate Melissa. And I have now reached the point in my legal career where I don't listen to the Supreme Court arguments. I just listen to Strict Scrutiny summary of them. So that is one way that I'm tending to my mental health. And it's very effective. So I want to sort of really circle back to where Melissa started. And I'm going to start with a story, which is it's May of 2022, and I'm in North Carolina to defend an expert deposition. One of my very least favorite things to do, because you sort of sit there for 8 hours and just hope your witness doesn't say anything terrible, but all you can do is object, and they still have to answer all the questions. And so I'm anxious. It's the night before, so I'm like, what am I going to do? Obviously, I'm going to watch the Met Gala red carpet. And turns out this is not your normal Met Gala red carpet night, because the Dobbs leak happens. And it was very Hunger Games. You're like watching the Met Gala, and then you sort of have a glimpse of what's going on outside the Capitol, and it's not good. And so when I read the Dobbs leaked opinion, which almost identically mirrored the actual opinion that came out the next month, the thing that haunted me, and was the right feeling, was the paragraph on equal protection. And the only time that the Geduldig decision had really been used consistently in litigation was by governments defending anti-trans laws and policies, because it had largely been considered to be an absurd opinion, but it was used in litigation against us to argue that laws that target, gender transition or gender dysphoria are not actually trans status-based flaws, just because it is targeting something that only trans people undergo or experience. Because the sort of flip side of the part of Geduldig that you raised, which is not all women get pregnant, was that only people assigned female at birth get pregnant. And given that, the court in essence said that's not enough to make it a sex-based classification. And that has been the provision that has haunted us. And so when the Dobbs decision came down, I knew it was going to be the thing that both culturally and doctrinally started to erode our ability to advance trans rights in political spaces and in courts. And so what happened was, at the beginning of 2023, it was in essence even more open season on trans people in state legislatures. And this was because I think there was this cultural sense that, we're just doing away with, the constitutional rights related to bodily autonomy. That's sort of the one atmospheric thing that happened. And then as a practical matter, a lot of the energy and resources that had gone into anti-abortion laws and advocacy that were, trying to negotiate around Roe could be shifted into anti-trans laws and policies in state legislatures. And so when we went into state legislative session at the beginning of 2023, we were told by our Republican lobbyists, by everyone that we had worked with, was there is literally nothing you can do. These bills are passing, and that was what happened. You had basically by the end of 2023, 25 states banning gender-affirming medical care for trans adolescents, half the country banning participation of trans women and girls in sports, and concurrently, the early successes that we had in litigating against these laws started to be overturned, most notably by the Sixth Circuit in Skrmetti, with Chief Judge Sutton saying, this is a law that says no medical treatment for gender transition. And one might think that the recent Supreme Court decision most relevant to that kind of law would be Bostock, a law that says it is in fact sex-based to target or discriminate against trans people. But no, the relevant law for Chief Judge Sutton was Dobbs. And so Dobbs comes in doctrinally, in essence, to say that there is no heightened protection or heightened scrutiny owed to these laws because they are neither sex-based on their face, even though they prohibit sex transition by their own language, and there is no trans status classification because this is just, it's just a coincidence. Nobody can, have access to sex transition treatments, not just trans people. And that sort of really relies on the absurd logic of Geduldig, really reanimating the decision and using the fact that Alito has this equal protection paragraph that is now being weaponized to erode constitutional protections for everyone, and in particular for trans people. And going back to Paisley's point, the doctrinal entry point now to abrogate the sex-based protections is a tax on trans people, but it is going to have an impact on everyone's equal protection ability to be protected under the Equal Protection Clause. And so in a post-Dobbs world, politically, culturally, doctrinally, you can start to see how we have shifted what is acceptable to the point where we now are calling into question centrally important cases like United States versus Virginia. Because in United States versus Virginia, the court says all sex-based classifications get heightened scrutiny. And so if the court in Skrmetti ultimately says, well, a prohibition on medical treatment to undergo some sort of sex transition, which is how the statute phrases the prohibition, you have to, in essence, say that something about certain types of sex classifications don't get that heightened protections. And you are, whether explicitly or implicitly, starting to erode these core constitutional protections that have protected everyone, not just trans people. And so one of the things that feels really important to say when we're looking at the future post-Dobbs of individual rights is that a real hazard, I think, of movement work that over-relies on law is that it over-relies on individual rights. It over-focuses on the individual, because one individual's right can always be in conflict with another person's individual right. And if we're not looking at the collective, if we're not making collective demands, we run the risk of individualizing everything and over-relying on the court system and the articulation of injury-based protections, which is what all of the equal protection and civil rights litigation demands. And I think we're ultimately doing a disservice to our collective movement work, which, as we can see in this moment, we so desperately need. And so one hope that I have is that as we continue to see the erosion of our individual rights by the court, as we continue to see the underprotection of our communities by the state, that we move away from this litigation addiction that we have in this country and towards some sort of more collectivized action. Because you can see, too, if you look at, for example, the Trump administration is dismantling the Department of Education, except insofar as it can weaponize the individual rights of white people and of cis women to not be injured by the existence of trans people, and of Christians to not, have to serve LGBTQ customers when, that's not in the Department of Education context, obviously, but, same idea. So all that to say, I think, in our sort of imagination, as everything collapses around us, maybe one thing that we can do is turn less toward this articulation of our states of injury, as Wendy Brown would say, like in the individual rights framework, and think more about collective demand. And that, I think, is the silver lining that I'm going to look for as we start to make more justice-oriented demands moving forward.
All right, thank you so much. So before we turn to the Q&A from the audience, we're going to have kind of Q&A amongst the panelists first for maybe 15 minutes or so. So we'll, does any panelist have a question that they want to ask another? Well, I'll start off, because I think it's so interesting, right? Like gender neutrality and sex difference. Like, how is the administration? Well, I know I'm mixing the branches up. So we have the executive and the judge, but still, how do these different things go together? Someone told me the other day, like, Hegsworth is getting rid of the idea that men and women should have different fitness standards in the military because he wants there to be gender neutrality, even as Trump is really insisting on sex difference. Like, how do we think about those two things together?
I think it's a question that actually engages the point that Nelson made about religion. We have, on the one hand, this effort to be neutral as to free exercise, but then you have the diminution of the Establishment Clause and the government's ability to essentially endorse a particular religion. So I mean, like the same dynamic is happening in the religion space too.
Yeah, I mean, I'm curious to know, because you guys are much more expert on these issues of trans-constitutional politics and how they relate to other branches of constitutional politics, but it seems like I would love it to be the case that there's like solidarity among these different rights bearers, and that what's bad for trans people will also be bad for everyone else. And I think that's true in a way. Like, of course it's true, and like, I want it to be true. But I also see that like the ability of especially the sort of movement conservatives to differentiate these rights in ways that don't make sense. They're not principled. Like, this is not a consistent. Is very profound, right? So that it may well be the case that trans politics is just different from lesbian politics. It's different from marriage equality. It's different, right? And that even though it doesn't make sense in terms of our law, that these rights can be disaggregated and targeted separately. I'm just curious about what you think about that. Is Obergefell going to go down as well, or the politics really different around that?
Well, I think the politics are really different. And I think, again, I actually think what comes out of Dobbs most immediately is actually that equal protection paragraph more than the sort of substantive due process, not, sort of operating in the background. I think another interesting point there is that the Supreme Court in Skrmetti took the equal protection question and not the substantive due process question. And there's lots of reasons for that. I think they just don't know what they want to do, what bad things they want to do with substantive due process. And they want to save that for another day. Whereas I think they know, and maybe I'll be surprised, what bad things they want to do with equal protection, which I think is reinforce Geduldig and abrogate Virginia. I think one other sort of common problem here, I think, is our sort of anti-classification world of equal protection doctrine, which is to say that I think instead of sort of recognizing that there is a difference between a race-based classification that affects Black people and a race-based classification, or negatively affects Black people, and a race-based classification designed to rectify past discrimination, instead say, well, we can't, Justice O'Connor, we can't possibly know it's all going to receive the same level of scrutiny, I think has haunted us in everything that we've done. And now we're trying to advance a sort of pro-classification analysis to get heightened scrutiny in our context, but I think we would have better served all the work if we had leaned in to an anti-subordination frame instead of sort of accepting the anti-classification one. Obviously, it wasn't going to win the day, particularly with this court, but I think it's going to come back to haunt us repeatedly.
Okay. Yes. So the microphone, please. Yeah. At the back, I think.
Yeah. So I've been spending a lot of time recently on the quote-unquote anti-Semitism fight involving universities. There's a lot to talk about. I'll be quick. So with Khalil, who's a green card holder, that's kind of shocking, obviously. With the woman whose name I can't remember at Tufts, that's in some ways even more shocking because all she did was write an op-ed in the school newspaper. I don't mean at all to diminish the threat to immigrants that both of these represent. But what I'm trying to understand is the argument that people are making. I think I saw Timothy Snyder make this argument, that if the president can say to a green card holder, for instance, ICE can arrest you and I'm revoking your green card, can he also revoke anyone's citizenship and do the same thing? In other words, have we all lost our rights under this doctrine? Are those two things sufficiently related for something like that to be of concern?
Thank you for the question. So there is a universe that has happened where U.S. citizens have had, who are citizens by naturalization, have had their naturalization rescinded. There's a process just like a green card holder. Green card holders can lose their status, and there's a process for it. And so I think marrying the two is not out of the question. Certainly where we've seen denaturalization cases have the most teeth from the government side have been in this amorphous category of national security and those interests. And what we're seeing happening to Ms. Ozturk and to Mr. Khalil and many of the other individuals who are being currently detained, it's coming under this this framework of the foreign policy bar, and then already, which is a similar idea, this kind of overarching one person makes a decision, and now everything else goes out the window, and so you can see like that it does endanger anyone who is vulnerable to having their status, including naturalized citizens, be taken away, and you're also seeing the cleanup that's starting to happen, where people end up getting ensnared using, again, this like one determination made by someone that's against the interests, like the United States foreign policy interests, and then you're seeing people scour through applications. So I'm sure anybody who's had to file an application with immigration agencies know that you're asked to fill out a ridiculously long set of questions that ask you about everything under the sun, including your membership in organizations and whatnot. And we see that in Mr. Khalil's case, after they already decided to retaliate against him, after they invoke this very broad bar, now they're like looking at his applications and saying, well, did you say, is this the correct date that you listed? Did you mention your membership in this group? We're going to assume you're a member of this group, even though you're not a member of this group and you didn't list it. That kind of the way that I hate to say, I use the term sometimes, and I think it's wrong to say that immigration law has been weaponized in this way. And I hate to say that because I think immigration law is always used for reasons that are not related to management of migration. So it's hard to say it's being weaponized when it's always being weaponized. But in any event, I do think that it could be used towards naturalized citizens in this way, inappropriately for all the reasons we're arguing here, but it isn't out of the question. And so anytime you have a situation where essentially one person is given all of the power to make these decisions, obviously that opens the door for them to use this power and work their way up the chain towards vulnerability. And I say this for naturalized citizens, but obviously we have a whole separate problem that's happening with birthright citizenship, where that's certainly being contested. I feel much more optimistic that the courts are, as it works its way up and is up, that will not be successful. But the fact that you see fringe legal theories that have been debunked for years, and this is one area where one of those old Supreme Court cases is actually very helpful and good, even that seems fair game, I think only underscores the vulnerability that we all have.
I have a question for Nelson. Okay, on a different note, do you think that Tinker versus Demois should be overturned with all the chaos between different universities, especially Columbia? People suing for Title VI and assaults on individual rights, with also, on the same note of the First Amendment, freedom of speech, freedom of assembly, when people are blocking other people from going to the libraries, going to classes, or let's say, like, when both Zionists, Palestinians, whatever, both sides, are calling for the annihilation of each other, or versus, like, when calling for the annihilation of an actual terrorist organization, or multiple of them, like Hamas, Hezbollah, ISIS, Taliban. Do you think that would still be covered under freedom of speech, freedom of assembly?
Sorry, are you done?
Yeah.
Okay. Yeah, this is obviously a very difficult area. It's difficult politically. It's also pretty complicated legally, but I'll just sort of sketch out a few principles that I think might help us talk about it. Tinker. Okay, so first of all, whether the First Amendment applies at all depends on whether the university at issue is public or private, right? So Brooklyn College is a public university, I'm assuming. I think this is right. It turns out sometimes you have to litigate these questions. Cornell, where I work, is sort of half land-grant universities and half not, but there's case law saying that it's private for these purposes, so it's not bound by the First Amendment in the same way. So that that first of all matters, right? Oh, have you? Yeah, that's not totally surprising to me. Also, the line is thinner than you might think because many private universities have adopted sort of the principles of the First Amendment for, just voluntarily. They said, like, we're going to follow, free speech principles as set forth by the Supreme Court. So the line matters, but it maybe doesn't matter as much as you think. Tinker itself was about, primary schools. So that was a situation where a student wanted to wear a black armband in protest of the Vietnam War. The Supreme Court said they have a right to do that. In subsequent cases, though, the Supreme Court has clarified that students in primary schools have limited rights of speech, right? So that case isn't totally relevant at the university context because younger students are in a different position, the court has recognized. But the big question is, what is the relationship between civil rights laws that protect the ability of every student to go to school without being harassed, whether the student is at a private university or a public university? What's the relationship between that and the speech rights of other students, especially around this particular conflict since October 7th, 2023, where there's a kind of mutual vulnerability, right, or a perceived mutual vulnerability between these two groups. And that's a very, very complicated question. For sure, the university, just to answer one of your specific questions, for sure the university can require pathways to be clear so that students can actually use the university in the way that it's intended to be used. As long as they do that in a content neutral and viewpoint neutral way, that's definitely okay for the university to do. But beyond that, I think we have to find a way as a country to both protect vulnerable students against harassment on the basis of that vulnerability and protect the ability of everyone to express themselves in a way that's free.
Well, actually, maybe we'll come back to you so everybody can have a chance, but you go to the gentleman in the jacket.
Hello, my name is Bobby. Last name disavowed due to very conservative. I will never associate with any conservative, So I got a question for Chase Strangio. You're the famous guy that argued before United States versus Skrmetti, right? Right? So what does your oral arguments prove about the Supreme Court of the United States and America as a whole in regards to trans people?
What is the oral argument itself? I guess the question in the case is really, are the broad constitutional principles that the court has articulated in other contexts going to continue to apply when the state law at issue is one that is, on its face targeting trans people? I think the thing that is most relevant for me moving forward is, what is the overall, sort of material and doctrinal impact of what we've come to rely on in a post-Dobbs world? So coming back to all of these questions, are there sex-based protections like we had understood previously? I think probably not. To what extent are some groups of people going to be carved out from the doctrine, or are they just going to, sort of abrogate the doctrine as a whole? I think one of the things that coming back to, I think the question of sort of how does this notion of a sex-based rights theory that is designed to exclude trans people operate without constraining everyone? And it's almost impossible to explain something like who gets protected under the Trump administration's definition of defending women without relying on sort of deeply misogynistic norms that are entrenching a version of the sex binary that is harmful to everyone. And so I think the relevance of Skrmetti, in this era is to sort of ask, are we going to have a set of constitutional norms that are going to, make more political and cultural space for the types of regressive sex-based demands that we're seeing. If you look at the data coming out of the election, you see this, very significant divergence between young men and young women, and the way in which the 2024 election was so much about sex generally, not about trans people. We were just a vehicle through which, there could be this retrenchment about the roles of men and women in society. And I think ultimately that's what Skrmetti is about. And, more so than it is just about, do trans people have constitutional rights?
Hi, thank you all so much. Thank you for being so generous with your time and with your wonderful knowledge. It's been an amazing panel. I have a very basic question for Mr. Strangio. You had spoken about how Dobbs implicates both equal protection in the majority opinion and substantive due process in the Thomas concurrence. And obviously, the Skrmetti case is in some ways analogous to Loving, which implicates both. Which kind of avenue do you think has more legal promise in the aftermath of Dobbs and more legal risk in the current Supreme Court environment, but also in the lower courts? And if you want to kind of forego the litigation avenue altogether, exactly what kind of political power building project do you want to engage in that can empower trans people? I know it's a big question. Thank you so much.
Well, I personally am not going to forego litigation altogether. I think that I'm going to sort of account for its harms and sort of make space for other projects. And probably everyone on the panel could speak to the sort of different doctrinal ways in which Dobbs is going to impact other work. In terms of Skrmetti, and the ways in which we litigated all of the bans on healthcare for trans minors, we brought both equal protection and substantive due process claims. I think the risk of the substantive due process claim was that we articulated it as a parental rights claim, and the parental rights framework is one that has its own hazards that we have to account for. One of which being the fact that it is deployed most commonly by conservatives. It undermines the autonomy of young people and is many young people have parents who don't support their existence as LGBTQ people, their ability to get abortion, to access contraception. So there's lots of risks of the argument, and that has been very complicated to litigate because of that. The court didn't even take that question, and so that sort of left to fight another day. Barrett asked a lot of questions about the substantive due process arguments at argument, I think, as a way to be like, yes, I'm ruling against you, but look, you have this other avenue. We will also rule against you in the future. But I think with the equal protection argument, the risk is that, and this is not a risk that would prevent me from litigating it, that like in so many contexts, like the political context, that the court will use the sort of relative, the relative marginalization of trans people to make a doctrinal rule, going back to the point about immigrants too. If they're going to make a First Amendment rule that, is applying to people based on their immigration status, but ultimately it erodes the protections for everyone, I think that's the real risk here, that they're going to set a rule that is going to fundamentally change sex discrimination doctrine, and people are not going to recognize that because it's going to seem upon first read that it's just about trans people. But I'm curious what others on the panel think about that and our litigation strategies. Feel free to critique them.
If I could just add one little fact, a lot of the state laws banning gender-affirming care for trans youth, some of them say youth is 19 and under. It's like, why that? It's like they're trying to just get a foot in the door of being able to ban trans care for gender-affirming care for adults. So they're like, that's the kind of like sneaky stuff that they're thinking of. So.
Yeah, and I think, yes, absolutely. And this came up a lot at argument, which was, the question is, well, if this isn't a sex line, then neither would a ban from Congress on gender-affirming care for people of all ages. And that, of course, is true. It's going to be impossible for them to draw that line without it affecting all of the other litigation. I think coming back to the question of what other power-building projects we need to do, I think we have to not in every instance think that the law is going to provide the answer, because I think we're seeing over and over again how that's not true, especially as we go up in the courts. Although, yay for Wisconsin last night, and plug for state courts. But I think we have a lot of work to do to change the way in which we interact with each other. And again, I think a lot of the questions demonstrate that individual rights can be pitched as in tension with one another, and that can undermine our political projects.
Okay, good.
So if you're a law student, don't listen to check your feed or something like that. This is more of a personal question for you. I'm married to a civil rights lawyer, and we constantly argue. I don't have faith in the legal system, and I don't think it's going to work out. I don't think that it will keep us safe. So I think of somebody like Dean Spade, who talks about the full master's tools will not take the master's house. The full quote is, for a little while, you might be able to use them to keep people safe. And so that's kind of how I see Alina's work, at least, is in the short term, it's useful. But my question is, why do you have faith in this? And if you can see yourself in 20 years from now, is this just like a stopgap, is use the courts, and then in 20 years, you'll be in the streets throwing bricks?
Okay. Well, I'll jump in there, although I think this is a great question for everyone. So I don't want to give the impression that I have faith in the legal system. I think that, honestly, in my work, the legal system itself is like the oppressive tool, and then we're fighting within that system because we have to. I have faith in people. And I think when I lose faith in people, that, then it's the soul-crushing internal dialogue that maybe happens several times a day. But for the most part, I have faith in people, and people are part of these systems. So our litigation, I've seen this time and time again. We will come up as lawyers with arguments and do the best we can. We, try to emulate the brilliance around us, but I'm sure fall short all the time. What I've seen make the difference is people. So I know that when we went in to fight for Ravi's freedom when he was detained in the first administration, yes, we marshaled our arguments, but it was the fact that the courtroom was packed, that there were rallies in the streets, that there were protests, that faith leaders were out front kind of denouncing what was happening, that I truly believe moved, the people involved in the decision making. And now that we've had the benefit of time, some of that kind of comes out where you see people, when Ravi got his pardon, we've had people who are involved in his criminal prosecution come to us and say, I'm so glad this happened. This was the right thing. So you get a sense that at the end of the day, we're all human beings. And so that's what I have faith in. But I do agree that it takes all the tools, all the things to be happening at the same time to make any one thing, eke out a small victory. And, big fan of redefining victory these days as being really an important part of the process. But I would love to hear what other folks think as well.
So Dean is a lawyer, I think is important to note, and I worked at the Sylvia Rivera Law Project where we did legal work, and I think I too believe, I believe in keeping people, I believe in people being alive in order to do the political projects, the caretaking work, and I do think that sometimes the legal work we do helps people stay alive longer, and if we think about the government, I'm always going to be someone who feels adverse to the government. I think that is, I feel very strongly in that, fighting the government. And so fighting the government can mean creating space for people to be more free, more alive, more creative. And when I was at Sylvia Rivera Law Project, a lot of the work that we did was going to court to create more space for people's material well-being. And that's true whether you're doing direct services, whether you're doing impact litigation, whether you're, theorizing. I think there is work to be done to keep people alive for longer, to do the other types of work we need.
So there's a deep pessimism in your question that I feel both an affinity for, but I also feel somewhat repulsed by. And I'm not a natural optimist, like full disclosure, I'm not. If you listen to Strict Scrutiny, like Kate is the optimist, Leah and I are the pessimists, full stop. But I will say this, the law is a weapon like anything else. And right now it is being marshaled in particular ways by individuals with a particular project. That hasn't always been the case. Right? It has been the case in the past that the law was marshaled in different ways for different ends with fundamentally different results. Like, I was born in 1975, so I'll be 50 this year. I remember being 8 years old in 1983 and going with my parents to Washington, D.C. And my father, who immigrated to this country from Jamaica to attend Howard, took me to Woodward and Lathrop's, which was a department store in Washington, D.C. that is no longer in existence. And I remember him walking me into the store and telling me that he worked here. And I asked him, did you work at the till? Like, were you a cashier? He was like, oh, no. I couldn't have worked at the cashier. I came here in 1953, and the only way someone like me could work here was in the back where I couldn't be seen because of segregation. And it was the first time in my life that I'd actually understood that someone I knew had experienced segregation in an actual way. And it shouldn't have surprised me. I mean, okay, I was 8 and I wasn't a savant or anything, but segregation was not that far removed from where I sat in 1983. I was born in 1975. That's only 21 years after Brown. The long tail of discrimination was still with us. I grew up in Florida. I felt it every day, so it shouldn't have been a surprise. But it was surprising to me because I lived in a world where we existed in a relatively integrated milieu. Now, to be fair, my generation is probably the only generation to experience true public school integration, and we've seen a retrenchment since then. But the fact that that moment existed means that it can exist again, right? And it wasn't just because of law, it was because of all of the other things that everyone on this panel has talked about, other forms of power and authority working in concert with law to achieve these results. It wasn't just Thurgood Marshall, it was Thurgood Marshall working in concert with Constance Baker Motley and Martin Luther King doing different kinds of mobilization in different spaces. And so I know this is an incredibly desultory moment and it feels like everything is caving in because it is. But it doesn't have to cave in forever. And it doesn't have to be the case that we are resigned to this fate. Like, we can marshal the tools that we have. We can marshal the solidarity that we feel in this moment to push back, and we should. What's happening to Alina's clients are things that could happen to all of us. We should take that seriously. Whether you are naturalized or a birthright citizen, all of this could happen to us. And that's the point, to find the most vulnerable people and then move up the chain. But if we stop them from moving up the chain, if we say not on our watch, not on our names right now, it's harder for them to do that. And so the question isn't like, what are we going to do about the law? It's like, what are we going to do about right now together with the law and with everything else that we have in our toolkits to marshal the power that we have? We do have power. We saw it last night in Wisconsin. Like, a bunch of voters just toppled the richest man in the world who tried to buy an election. So we can do this. We just have to want to, and we have to want to work together to do it, which means maybe moving past whatever disagreements we have about all kinds of things in order to work together for a moment that's bigger than each of us is individually.
I'm actually wondering about the intersection of both, where Dobbs leaves us, both with religious rights, because yes, it's in the name of Christianity and Christian religious rights, but there are other religions like mine where I am required to get an abortion if I end up pregnant, and that affects, negatively risks my life and health. Not just, in the immediate might die, but like my mental health, my future health. And speaking as a trans person with a genetic condition that causes cancer and is hormonal responsive, how do those things intersect, and then factoring disability rights in with that?
Yeah, it's a great question. I mean, it gets to, an issue that was raised in passing earlier, which is, do you use the oppressor's tools or not, right? And so there is litigation that's pending right now where people are saying, look, I have a religious belief that would require me to terminate a pregnancy under certain circumstances. And under the very vigorous, protective, free exercise law that the Supreme Court has adopted and articulated recently, I should get protection. Just very quickly, so like the form that conservatives sometimes use is, well, you're exempting that person, so you have to exempt me, otherwise it's religious discrimination. Well, almost all abortion bans exempt IVF. So if you're exempting IVF and you're not exempting me as a religious person, that's religious discrimination, right? That's the form of the claim. It's very, very strong, this claim, under articulated Supreme Court law as it stands right now. And it's going to win in certain, already in the Indiana courts, it's winning. That argument is winning. Will it win in the United States Supreme Court? It will not. Because of just some of the dynamics that we've already described. The court's tolerance for contradiction is, very high, right? So it's, they're going to find a way. But that doesn't mean that it's not valuable, right? To get to some of the, it doesn't mean it's not valuable to litigate this question in Indiana State Court. Like, it's super valuable. It raises the salience of the issue. It could help people in Indiana, at least for a time, right? So I'm not, a romantic about the possibilities of law at all, but nor am I romantic about the possibilities of any institution that we have available to us. Universities, corporations, churches, like again and again, like you could go on and on, but power works differently in different institutions. And, we have opportunities to take advantage of those differences and to leverage them in the service of like the thing that we should have faith in, which is the ability of the people to govern themselves.
Okay, we have time for one more question. David, been here all morning, so. Yeah.
I won't ask the question I would have asked this morning, but I'm not a lawyer, I'm a historian. I don't work in the US, I work in France. But I'm struck in this discussion by this emphasis on the sort of rights regime that exists in the United States and the importance of individualism. And I'm wondering if in your different areas you see any intriguing models out there of other rights regimes. And I realize the Supreme Court is not interested in what goes on in other countries. Okay.
Unless it's
for the
bad,
moment.
Then they are.
But is there something in your particular areas where there are some other models that might be of interest?
So Christina's colleague, Jamal Green at Columbia Law School, has written a really terrific book, How Rights Went Wrong, I think it's called. And it focuses on other systems which use a sort of proportionality framework for rights, which is to say that rights aren't a zero-sum game, like I have this right and it trumps whatever. Rights aren't trumps. But rather, like, we think about the exercise of the right in proportion to what may be retracted because of the exercise. And so it's a more kind of nuanced way of thinking about it. He argues that it ought to be one that is advanced in this system, especially where rights are often in conflict. Like, I've written in my own work about how in the marriage equality debate, the right to marry the person of the same sex or even to be recognized as such often came in conflict with the rights of parents to direct the upbringing of their children or to determine curricula or whatnot. And so rights are often in conflict, and a proportionality-based approach to them might help to resolve some of those conflicts more easily.
I mean, I also think that constitutional systems that put more or any sort of emphasis on economic-based rights or you know, I never understood the difference between positive and negative because it seemed like you could articulate everything either way. But I think more, you know, that we, like our court early on was like, well, we couldn't possibly recognize a sort of status in a class-based way in terms of economic-based rights, or else the entire system of the United States would crumble because our particular capitalism, I think because of that, a lot has been impacted and we don't sort of have much of an emphasis on anything about people's material well-being in our constitutional structure. And so I think when we look in other places, that's a real difference. But I think the unfortunate thing is the courts, federal courts in particular in the United States, don't care about what other countries are doing. But I just to note, it is very frustrating in the anti-trans context because they're very concerned about what the nationalized health systems in Europe are doing when they're bad. And so I just want to, again, point out it's not like the principles apply equally. So even if you were able to advance something in one context, it would most likely be weaponized against you again.
All right, well, thank you so much for giving the hands to the camera.
Yeah. It felt good. I was like, Wisconsin.
And they didn't mind by that much in Florida.
Yeah, they didn't mind by much in Florida. I was like, they're all
Moderating.
and it's also very grim. Like this, but also like we still have good people doing good things.